The government just admitted that suppressors are protected arms under the Second Amendment. So why can you still face 10 years in federal prison for owning one without their permission? Here's what's happening right now. The Fifth Circuit just dropped a decision in the Peterson case that could let the government tax and register any firearm you own, and it's heading to en banc review as we speak. But here's the shocking part. The Trump DOJ just asked for more time because they're reconsidering their position on suppressors again. And what they decide in the next 2 weeks could change everything. Hit that subscribe button and turn on notifications right now so you never miss updates on cases that directly affect your rights, because this one matters. The case that could end the Second Amendment. So let me tell you about the Peterson case, because what just happened here should terrify every gun owner in America. This case is called United States versus Peterson, and on the surface, it's about whether the NFA's suppressor restrictions violate the Second Amendment. But what it's really about is whether the government can admit you have a constitutional right and then tax it, register it, and make you wait 9 months to exercise that right. Mr. Peterson challenged his conviction under the NFA, arguing that these suppressor restrictions are blatantly unconstitutional. And initially, the Fifth Circuit 3-judge panel said suppressors aren't even arms. They don't get Second Amendment protection at all. That was a crushing defeat. But then something unprecedented happened. The Trump DOJ, through Attorney General Pam Bondi, filed a brief completely reversing the government's position. They admitted, finally, that suppressors are protected arms under the Second Amendment. They even said suppressors cannot be outright banned. That should have been game over, right? The government admits they're protected. Case closed. Wrong. Because in the same breath, the DOJ said the NFA's restrictions don't count as a ban. They claim making you pay $200, submit fingerprints, wait months for approval, and register your suppressor with the federal government somehow doesn't violate your rights. After that bombshell, the Fifth Circuit en banc panel mooted the original petition. Then the 3-judge panel withdrew their first opinion and issued a brand new decision. And what they just ruled is going to make your blood boil. The outrageous ruling. They just released this new ruling, and once again, they upheld the NFA's restrictions on suppressors. Now, they had to admit suppressors are arms. They couldn't deny that anymore after the DOJ's reversal. But here's where it gets insane. They claim the NFA doesn't violate the Second Amendment because it operates as a shall-issue permit scheme. Let that sink in for a second. According to this panel, the government can admit you have a constitutional right, but as long as they eventually issue you a permit after you pay them money and jump through their hoops, it's constitutional. This is coming from the Fifth Circuit, a court that's supposed to be strong on gun rights, and the implications of this decision are absolutely terrifying. Because if this logic stands, there's nothing stopping any government, federal or state, from requiring permits, taxes, and registration for any firearm. They could make you pay $200 and wait 9 months to buy a Glock. They could require registration of every AR-15. As long as they eventually approve you, they're saying it's constitutional. This is the shall-issue loophole that could destroy the Second Amendment. But here's where it gets interesting. Multiple Second Amendment organizations have joined this fight. The case is heading back to the Fifth Circuit en banc panel, and just days ago, the Trump DOJ filed a request for an extension. They need more time to file their response because, and this is critical, they're consulting with the administration to figure out their position. That means the DOJ might be shifting their stance on suppressors again, and what they decide could either save this case or doom it. The backstory that changes everything. Now let me tell you how this case started, because it's going to make you furious. This goes back to 2022 when federal and local law enforcement executed search warrants at Mr. Peterson's home in Louisiana. He ran a home-based FFL, a small gun business operating out of his house. The ATF and local police raided both his home and his business, claiming there were problems with how he was running the store. They said there might have been straw purchases, some record-keeping issues, failure to submit certain forms to the ATF. They even claimed some products sold there later showed up at crime scenes. But here's the kicker. Out of everything they found during those searches, all the supposed violations, all the inventory, all the records, it was a single solvent trap in his bedroom safe that led to federal charges. One item in his personal safe in his bedroom. And that's what this entire constitutional case is built on. So Mr. Peterson did what any of us would do. He filed a motion to dismiss those charges, arguing the NFA's suppressor restrictions violate the Second Amendment. But the district court denied it. They said suppressors aren't protected arms, so his Second Amendment argument failed. He appealed to the Fifth Circuit, and the 3-judge panel sided with the Biden ATF and Biden DOJ They agreed, suppressors aren't protected. So his legal team filed for en banc rehearing in the Fifth Circuit, and that's when everything changed. The Trump administration came in and reversed the government's position. The DOJ admitted suppressors are arms. The original three-judge panel pulled their decision and reviewed the case again. And even after all of that, even after the government admitted suppressors are constitutionally protected, the panel still upheld the NFA's restrictions. That's where we are now. One man with one solvent trap in his bedroom safe is fighting a battle that could determine whether the government can tax and register every firearm in America. Why this is a 5-alarm fire. So despite both sides now agreeing that suppressors are protected arms, despite the Fifth Circuit acknowledging that fact, they still ruled the NFA can regulate them. Why? Because they claim the NFA operates as a shall-issue permit system, and that's supposedly constitutional under Bruin. And this is why gun owners across America should be paying attention to this case. The panel took language from Bruin about shall-issue concealed carry permits and twisted it to justify any restriction on any arm. They're essentially saying that as long as the government eventually issues a permit using objective criteria, they can restrict whatever they want. Think about what that means. The government could require a $200 tax stamp for every handgun. They could make you wait a year to buy a rifle. They could register every firearm you own. And according to this panel's logic, as long as they approve you eventually, it's constitutional. That's not how constitutional rights work. Imagine if the government said, "You have free speech, but you need to pay us $200 and wait 9 months for a permit every time you want to say something controversial." Or, "You have the right to vote, but you need to submit fingerprints, pass a background check, and get government approval first." We'd recognize that as tyranny. But apparently, when it comes to the Second Amendment, this panel thinks it's fine. Mr. Peterson's petition for en banc rehearing lays this out perfectly. He argues the panel completely mischaracterized how the NFA works. The NFA isn't a shall-issue CCW permit. It's a federal taxation and registration scheme. Those are fundamentally different things. A CCW permit is a state-level licensing system. The NFA is the federal government taxing a constitutional right and forcing you into a registry. The panel also treated the $200 NFA tax like it's just a routine licensing fee, but it's not a fee. It's a tax under the federal tax code, and you cannot tax constitutional rights. Here's the nightmare scenario. If this reasoning stands, the government could impose taxation and registration on any firearm, any accessory, any item they want to control. The Second Amendment becomes meaningless if the government can just tax it into oblivion. And it's not just Mr. Peterson saying this. The NRA and the ASA filed an amicus brief supporting his petition. They argue this decision sets a catastrophic precedent. If the government can require registration of suppressors while admitting they're protected arms, then the government can require registration of all arms without satisfying the Supreme Court's test for Second Amendment challenges. That's the endgame here. Universal gun registration under the guise of shall-issue permits. What happens next, and why it matters to you? This case is now heading to the Fifth Circuit en banc panel, and here's where things get critical. The en banc panel ordered the federal government to respond to Peterson's petition. That response was originally due on September 22nd, but the Trump administration requested an extension, and now their response is due on October 6th. We're talking about 2 weeks from now. But here's what you need to understand. In that extension request, the federal government said they need extra time to consult with the Department of Justice and the administration to determine their position in this case. Read that again. They're reconsidering their position. After already reversing course once and admitting suppressors are protected arms, they're now consulting internally to figure out what they're going to argue to the en banc panel. That could be incredible news. Maybe they're going to go even further and argue the NFA restrictions are unconstitutional, or it could be terrible news. Maybe they're walking back their position and preparing to defend the NFA again. We don't know yet, but in their own words, they stated, the government requests an additional 14 days to file its response in this matter. This would allow an opportunity to fully address the issues, and if needed, time to consult with the Department of Justice considering the government's position. So October 6th is the date to watch. That's when we'll see which direction the Trump DOJ is really going on suppressors. Are they going to fight for your rights, or are they going to compromise again? This case will likely be granted en banc review, which is actually good news because the Fifth Circuit en banc panel has delivered some strong Second Amendment wins in the past. But everything depends on what the DOJ says in 2 weeks. If they argue strongly against the NFA, we could see a historic win for gun rights. If they waffle, we could lose everything. Conclusion. So that's where we stand right now with the Peterson case. We're going to be monitoring this closely, and as soon as that October 6th response drops, I'll have a video breaking down exactly what the DOJ says and what it means for suppressor rights. If you want to stay updated on this case and other Second Amendment legal battles, make sure you're subscribed to the channel with notifications turned on. Now, I want to hear from you. Do you think the Trump DOJ is going to fully back Second Amendment rights on suppressors this time? Or are we going to see another disappointing compromise? Drop your thoughts in the comments below, and let's talk about it.